In a historic ruling Monday, the U.S. Supreme Court said it's illegal to fire a worker because of their sexual orientation or gender identity. Natalie Brand has the details.
In a landmark decision for LGBTQ rights, the Supreme Court ruled employers cannot discriminate on the basis of sexual orientation or gender identity. In a 6-3 ruling, the nation's highest court made it clear the Civil Rights Act of 1964 that bars discrimination on the basis of sex, race, color, origin, or religion protects gay and transgender workers.
It's been a long journey, but we finally made it here.
We interviewed plaintiff Gerald Bostock when he traveled to Washington for oral arguments last October. He says he lost his job in Clayton County, Georgia, after joining a gay softball league.
I did nothing wrong, and now I have some validation in that.
Bostock's was one of 3 cases heard at the court that day. Amy Stevens, who says she was fired for being transgender, wrote a statement before passing away last month, saying in part, "I am glad the court recognized that what happened to me is wrong and illegal."
We can go to work and not have to be in fear that being gay, lesbian, bisexual, or transgender will now be a blank check for employers to discriminate against us.
Sharon McGowan of Lambda Legal has been litigating these cases for more than 15 years. She says the significance of today's ruling, it will create a uniform standard nationwide.
It doesn't matter whether you work in Illinois or Missouri. It doesn't matter whether or not you are in Ohio or Indiana. You will now have the full protection of federal law.
Justices Samuel Alito, Clarence Thomas, and Brett Kavanaugh dissented. Justice Kavanaugh wrote, "We are judges, not members of Congress. Our role is not to make or amend the law." But in the majority opinion, Justice Neil Gorsuch wrote, "An employer who fires an individual merely for being gay or transgender defies the laws." Natalie Brand, CBS News, Washington.
For more on this, Loyola Law School professor Jessica Levinson joins me now. Professor, thanks very much for being with us. The new ruling is an expansion of Title VII of the Civil Rights Act. Can you explain that law and how it works?
Sure. So Title VII was part of the landmark 1964 Civil Rights Act. It was meant to protect people from discrimination based on race, color, or national origin. An interesting aside is that the word sex was actually added at the very last minute as part of a poison pill. So there were certain Southern senators who were hoping, Congress isn't going to pass this landmark piece of legislation if we add that you can't discriminate on the basis of sex. They were wrong. And so we had that really important word that was part of Title VII. And that word, of course, is what the entire Supreme Court case hinged on today. And whether or not the prohibition that you cannot discriminate in the workplace on the basis of sex included discrimination that would happen based on sexual orientation or gender identity. It's a very narrow legal question, but it has, of course, huge practical implications for many people across the nation who, as of this morning, could get married on Sunday night, but then fired for that marriage on Monday morning. And now that's no longer true.
Wow, it's so fascinating to hear, Professor, that history behind the Civil Rights Act and the insertion of that one word, which, as you point out, really was so critical regarding what we're talking about at this moment. How can someone prove that they were fired on the basis of sexual orientation or gender identity? What will that process be like going forward?
It will be the same process that, frankly, many women and many minorities have been going through for decades now. And it's not an easy process. So as we all know, just in an intuitive sense, you can think, everybody can understand that you were fired because, let's say, you are a woman, or because you are Hispanic, or because you are fill in the blank protected class. But actually proving that that was the employer's reason, and that's what motivated the employer, and that's why you should get relief under federal law, is not very easy. It requires oftentimes getting a lot of resources, getting evidence and depositions from the employer to show that this was basically the cause. There's I would say it's not an easy battle to win, but let's not take anything away from today. This is a huge sea change that there's now a nationwide protection that you cannot be fired just based on sexual orientation or gender identity. As you point out, the next step is that it's not always easy to prove these cases, that employers will oftentimes say, no, it was because of poor performance. It wasn't because of your gender identity.
Well, it's really interesting because Justice Brett Kavanaugh said this decision should have been made by Congress and the president, not the Supreme Court. However, not all of his fellow conservatives on the high court agreed with him. Tell us more, first of all, about the dissenting opinion, and then just a little bit about how this decision actually broke.
Yeah, so this is a decision that it looks like it's a liberal win. And so people are saying, how could this conservative court come out with this liberal decision? And a conservative court where you have the author being a Trump appointee, an appointee by President Trump, Neil Gorsuch. And the answer is that this is actually a conservative judicial opinion in the sense that conservatives will say that they're textualists, that they're looking just at the text of a federal law or just at the text of the Constitution, and that they don't look at context. Because if you looked at context in this case, it's pretty clear that Congress did not intend to protect people based on gender identity or sexual orientation in 1964 when they passed this law. So it's a conservative opinion in the sense that it takes context out of the decision-making process to a certain extent, and it looks just at the word on the page. Now, you see this really interesting kind of split between Justice Kavanaugh and Justice Gorsuch, where Justice Gorsuch is saying, I have the right conservative judicial approach. I'm the one just looking at the word sex, and I can prove that I'm right, that it should include gender identity and sexual orientation. And then Justice Kavanaugh, the other President Trump appointee, on the other hand, saying, I think you're reading that single word wrong. And if you wanted to protect people based on gender identity and sexual orientation, I know how you do it. You do it through the legislative process. You insert 4 words into Title VII of the 1964 Civil Rights Act, and that's how you make sure that you protect these individuals. So really interesting legal argument that obviously split the conservative court in this case.
Well, the Trump administration has argued Congress should pass an entirely new law for sexual orientation-based discrimination as opposed to expanding Title VII. What's your take on it? What's your assessment of this idea of expanding the existing law as opposed to passing a new one?
Well, I mean, so this is a dance that we see so often happen between the Supreme Court when they're interpreting federal law and between Congress, where the Supreme Court is alternately saying, this is my role to interpret this particular phrase, or in this case, word. And Congress is saying, no, it isn't. And of course, in the background is the political reality that Congress is really not acting very often, particularly now, and that it's not at all clear that Congress would protect certain people from workplace discrimination. And so it's a legal question with huge political implications. In this case, the liberals were united, and it split the so-called contextualists. It split the conservative members of the court, with some saying, like Justice Kavanaugh, I'm not a lawmaker. It's not my role as a judge to expand that word. And then others like Justice Gorsuch and Chief Justice John Roberts saying, it's my job to interpret the law, and I'm comfortable reading into it this particular meaning.
Well, this ruling comes just days after the Trump administration rolled back an Obama-era policy that protected LGBTQ patients from discrimination. The Human Rights Campaign plans to sue. Where do you see this case heading?
Well, I think that it could head to the Supreme Court. One of the things that we should think about from the decision today is that this is the first time there's been a decision vindicating gay rights that was not authored by a justice named Anthony Kennedy. So in the past, every decision from the Supreme Court that protected and promoted gay rights, or I should say protected gay rights, was written by one justice. It was Anthony Kennedy. And everybody thought, what's going to happen a few years ago when Justice Kennedy retires? Now we know that we don't have, at least on these statutory interpretation cases, an even liberal conservative split. So when it comes to the decision that was just made yesterday, the rollback of protections, I think we could see something similar happen again if it comes back to the Supreme Court.
All right, we will be watching that closely. Professor Jessica Levinson. Professor, thanks very much for your time.
Thank you for having me.